Yeah, so from Frappe, we have Yashodhara and Ankita. And from Prighter, our representative for the EU and UK region, we have Andreas and Katrina, who will be talking about how their tool works with our Frappe products and how you can raise queries about your data and all. Sure. So let's begin. Before we start, I'd just like to give you a quick introduction of what Frappe technology is and who am I. So myself, Mayank, I have been with Frappe Technologies, initially working as consultant and now more on building family across European region. Frappe has been into business for more than 15 years now, and we have been catering to around 4,000 plus customers into different sections like products and services. Products includes one of our MVPs, which is ERP Next, and a lot of Frappe applications based on that. Also, we have services like Frappe School and certifications where we provide them educational content about ERP Next and Frappe framework. We have our partner resources. We have our team across the globe. We have more than 28 partners now. So now I would like Yashodhara to take over the audio and talk about her presentation.
Hello, everyone. I am Yashodhara Shukla, the Legal Associate at Frappe Technologies Private Limited. To begin with, I take this opportunity to thank each one of you for being a part of this informative and instructive webinar. The webinar has been organized to provide an insight into how we have conducted the GDPR compliance of Frappe's two celebrated verticals, Frappe Cloud and Frappe School. In order to provide a thorough understanding of our processes and functions, the webinar has been divided into 4 segments. So without much ado, let me quickly go over the 4 segments that this webinar entails and what each one covers. The first segment is an overview of the General Data Protection Regulation, or GDPR as it is commonly known, and will cover the key aspects of the privacy legislation, its impact, and the penalties for non-compliance. We'll also discuss the necessity of GDPR compliance in general, as well as what prompted Frappe to take this step. Segment 2 and 3 are primarily focused and Frappe School and include the elements that were introduced to preserve and exhibit conformity with the GDPR principles and other legislation mandated obligations. Now, Article 27 of the GDPR mandates that a non-EU company such as ours that provides services to individuals and entities in the EU must have an EU representative to act on their behalf. Thus, we have Prighter appointed as our EU and UK representative. The webinar finally concludes with segment 4, where Prighter will explain how to make use of the Prighter tool to access and exercise one's data subject rights. So the General Data Protection Regulation of the EU came into force on 25th May 2018. Since its very inception, GDPR bears the title of being the only data protection regulation that has trans-border enforceability and a broader area of application. The long-arm jurisdiction of GDPR extends to non-EU companies in their commercial transactions with the consumers of the EU. The GDPR applies to companies that interact with EU citizens, operate in the European Economic Area, employ EU citizens, and engage with companies that engage with EU citizens, thus magnifying the ambit of its applicability. Now we shall quickly discuss the principles of the GDPR. The GDPR enlists 7 principles that form the very foundation of it and are also quintessential to the performance of the mandated obligations under it. They are accountability, lawfulness, fairness, and transparency, purpose limitation, data minimization, storage limitation, integrity and confidentiality, and accuracy. The key requirements of the GDPR are primarily based on the principles that I just mentioned. The implementation of these principles, however, depends on the data processing activities of the company, the kind of data being processed, and the role undertaken by a company, whether it is of a data controller or a data processor. In the interest of time, I would stick to discussing the very essential requirements prescribed by the legislation. So the GDPR requires companies to limit processing and acquire only the data that is required. It also requires the companies to delete personal data once the processing purpose has been met. GDPR has also made the data subjects equipped by providing them with the ultimate control over their personal data so that the data subject has a lot of control over how much data they want to give to a company and how that data is being utilized. Additionally, the data subject has the right to request for his or her personal data to be corrected, object to its processing, file a complaint, or even get it deleted or transferred. The GDPR prohibits treating personal data for reasons other than the legitimate purpose for which it was acquired and prioritizes express and clear consent of the data subject and the right to withdraw his consent at any time. Now, since all of you have a basic idea of the GDPR, let us go and discuss the breaches and fines. So the GDPR has a reputation of slapping fines that amount to millions of euros, as its penalties range from 10 million euros and 2% of the annual global turnover of the company, whichever is higher, for less serious instances of non-compliance, to 20 million euros or 4% of the annual global turnover of the company, whichever is higher, for bigger, more serious infringements. Next slide, please. So now let's discuss why are we so worried about being GDPR compliant and why did Frappe take it into consideration? So amongst the many benefits of being GDPR compliant, such as protection from with an increase in accountability for organizations that process data and maintaining a robust and resilient privacy infrastructure in general, the two primary reasons that prompted Frappe to consider and accomplish such compliance are that, one, in organizations like Frappe, where software services are delivered through the internet, the amount of data processed naturally increases, and so do the privacy and security risks associated with it. Secondly, the processing of data in an organization such as ours make us both the data processors when acting on the customer's instructions when they are hosted on Frappe Cloud and data controllers when deciding the purposes and means of data processing, thus making it a complicated mix in the case of our company. With this, I shall hand over the presentation to my colleague Ankita to discuss the steps involved in GDPR compliance of Frappe Cloud and Frappe School. Over to you, Ankita.
Thank you, Yashodhara. I hope I'm audible and my screen is also visible. Hello, everyone. I'm Ankita and I'm a legal compliance officer with Frappe Technologies. I will walk you through of how we have achieved GDPR compliance for our two verticals, that is Frappe Cloud and Frappe School. Now let us begin. So Frappe Cloud is our cloud services and we host ERP Next via Frappe Cloud, whereas Frappe School is our learning management system through which we provide courses and certification to our users about ERP Next. In furtherance of legal parallels and GDPR compliance, we have drafted 4 lists of legal documents, that is, terms of use, that describes the Frappe and the customer responsibility in terms of service. Second, privacy policy governs of how Frappe is providing privacy to its users and customers. Third, cookie policy governs of how we manage the cookies in the system. And four, list of processors are basically third-party processor. For Frappe School, we do not have any list of processors since there is no involvement of third party in the system. We shall brief you on this in the further slides. Next slide, please. So both our verticals are GDPR compliant and have a well-equipped privacy policy. The privacy policy primarily governs, first, the information we collect from the customers. We collect information via 3 ways: provided manually by you, that is, provided specifically inserting your data. Second, provided automatically by you via cookies. And we receive information from third parties such as our payment service providers when you make a payment, and from GitHub when you import your source code into our website. The privacy policy also governs customer rights, that is basically data subject rights under GDPR and also enshrined under GDPR as mentioned by my colleague earlier in the presentation. We provide several rights to our customers via our privacy policy, that is right to erasure, right to delete data, right to access and correction, data portability, etc. Now, how can you exhibit these rights through Frappe Cloud and Frappe School? For Frappe Cloud, you can just generate a support request. Forum will share the link to that. And for Frappe School, you can generate it too. It has been already given for a data subject request as well. Yeah. For data access, for erasure or deletion of account, and for data portability also is shared by forum already. And if you wish to exercise right to rectification in Frappe School or you wish to object, then you can email us to school@frappe.io. Now, sharing of information with third parties. We have a list of processors, that is our payment gateways or our backend data servers, with whom all we have signed specific data processing agreements and agreed upon specific terms of service and privacy policy. You can look up into this on our website itself. We will share the link at the end of this presentation for your reference. Fourth, data storage and retention. For Frappe School and Frappe Cloud, we retain data for 180 days from the date you generate the account deletion request, unless you have any pending dues. Also, in case of Frappe Cloud, we retain with us backup for 6 months from the day you have generated deletion request, and you can retrieve your data from your account. We shall be covering the security aspect later when we are talking about the ISO certification. Now let's move on to cookie policy. The cookies are primarily divided into 3 categories: strictly necessary cookies or functional cookies, performance-based cookies, and analytic cookies. It should be highlighted that Frappe in no way tracks you, and that's the sole reason why we don't have any analytics cookies. In case of performance-based cookies, we do not have any performance-based cookies, and we collect only the cookies which are necessary for us to provide the customer the service. So we try to deliver the best service to our customers by providing the least amount of cookies. We do have third-party cookies, and that is because of the payment gateways, who are our third-party processors. Now you will be wondering, shouldn't we have a cookie banner? Do we really need it? Actually, no. We do not collect any data or store any customer cookies before the sign-up. Only at the time of sign up, we store cookies in your system and collect data from you and take explicit consent from you. Next slide, please. Now let's talk about the security aspect in our systems. How do we provide the security? As you may be aware that Frappe is now an ISO 27001-9001 certified company. Due to this procedure, we have set within the organization typical quality management systems and security risk assessments, which is followed by every department within Frappe. We ensure that security standards are met at all times of our customers, and due to which we conduct regular internal ISO audits and have regular surveillance check by our external auditors. In furtherance of ISO, we have different internal documents which are reviewed by our external auditors. That is access use policy, data retention policy, log management policy, password management policy, etc. So rest assured, we try to provide the best technical and security standards to our customers. Now, Andres and Katrina will be taking over from here, who represent Prighter, and they are our EU and UK representatives. As a brief, Andreas is the director of Prighter, and Katrina is a privacy professional with Prighter, who will walk you through of how you can use Prighter and exhibit your rights under GDPR. Over to you, Andreas and Katrina.
Thank you very much also for joining the webinar and for inviting us to take part in this. With me in the webinar is Katrina. She is a privacy professional here at Prighter, and I'm lawyer and CEO of Prighter. Thank you very much, everyone, for joining. And let me share my screen. Super. So, main question for us is, how can we enable Frappe as well as other non-European companies to become GDPR compliant, and how to assist in the European and the UK market to communicate with data subjects and authorities. For that, we build a range of products, which are service-related products. Here you can see the representation services and tech-related products. Frappe is using our representation services for Europe and the UK for privacy-related matters, and is also using the tech products, the so-called DSR tool, the tool for data subject requests, and for breach notifications to the authority, but also informations of data subjects about a data breach. Why all this is relevant? You heard already about the applicability of GDPR, what the principles of GDPR are, but why is GDPR applicable to a non-European company and so relevant around the world and what makes it to some kind of global standard for privacy regulations will be explained by Kati. She will dig into the territorial scope of GDPR as well as the role of the representative. And I will take afterwards again over for explaining you how this looks in detail.
Hi, everyone. So Frappe is an Indian company. So why is the GDPR relevant? Article 3 of the GDPR sets out the territorial scope of the regulation and states that it applies first to companies with an establishment in the EU, regardless of where the processing is taking place, and second, to companies with no establishment in the EU, such as Frappe, when reaching out to the European market. So reaching out to the European market can mean either offering goods or services to data subjects in the EU, irrespective of whether payment is required by the data subject, or monitoring of the behavior of data subjects in the EU, as far as the behavior takes place in the European Union. An example for that could be tracking of individuals' behavior over the internet. With regard to the UK, the same scenarios are triggering the applicability of the UK GDPR. It is to mention here that since Brexit, the EU GDPR is no longer applicable to the UK. However, the provisions of the EU GDPR have been incorporated directly into UK law as the UK GDPR. In practice, there's little change at the present to the core data protection principles, obligation, and rights of the EU GDPR in the UK law. The GDPR recitals, as before, are not legally binding, but continue to be useful for interpretation of the provisions of the regulation. Also, the UK Data Protection Authority, the ICO, continues to give way to the guidance of the European Data Protection Board. However, the data protection legislation will most likely become subject to change in the future, which outcome is unknown yet. So now, if you are an organization carrying out any of the activities listed here, in respect of both any of the EU27 member states and the UK, as Frappe does, then the EU GDPR applies to the extent that an organization operates in the European Economic Area, offering goods or services in the European Economic Area, or is monitoring behavior of individuals in the economic area. And second, the UK GDPR applies to the extent that an organization operates in the UK, offering goods and services to individuals in the UK, or monitoring behavior of individuals in the UK. Frappe provides its services internationally, including clients in the UK and the EU, and has therefore concluded that both the UK and the EU GDPR are applicable to its processing activities. So what does that now mean for Frappe? Given the broad territorial scope of the GDPR, the legislators wish to ensure that both data subjects and supervisory authorities were able to reach companies outside the UK or the EU. Frappe took a proactive approach to that and appointed Prighter as a representative in the UK and the EU to preserve ability of data subjects to exercise their rights and of regulators to reach out in respect of remedial work action or sanctions for non-compliance. As already heard, Article 27 requires a controller or processor not located in those territories to appoint a representative located in the UK or EU. If both the UK and the EU GDPR laws are applying, then a controller or processor has to appoint an EU representative under the EU GDPR and the UK representative under the UK GDPR. And through office locations and together with our unique network of partner offices, we cover all major EU member states and the UK. So Prighter can provide a one-stop shop for privacy representative services across the EU and the UK. So what is Prighter's role as a representative? As Frappe's representative, we first facilitate communication between Frappe and data subjects in order to ensure the data subjects can effectively exercise the rights. Second, representing Frappe in cooperating with the competent supervisory authorities and the commissioner in respect of any complaints to the supervisory authority and any resulting remedial or enforcement actions with the controller processor is required to take, or any fines or other sanctions imposed by the regulator for non-compliance with the GDPR. And lastly, facilitate communication between Frappe as a processor and the relevant data controller in instances where Frappe receives a data subject request, which should be handled by the controller. And Andreas will now explain you what this all means in practice and subsequently present you a demo.
Thank you, Kathy. Super. So let me dig a little bit into detail what this means, what we do for Frappe here in Europe, how to facilitate communication with data subjects is on the one hand that we ensure the information rights of data subjects around the world, but especially in Europe and the UK, to get informed about the processing activities. This is done via so-called compliance landing page, where Frappe can list privacy policies, certificates, and also offers an access point for afterwards the data subject rights. The so-called DSR tool provides data subjects with an easy and understandable way how to launch a data subject request, and makes it therefore for both sides, Frappe and the data subject, a structured process to run through that, with eliminating the email communication in it. Similar to that, the data breach notification is something Prighter provides Frappe with. In case of a data breach, the information needed for data subject can be done via the Prighter platform, and so we can inform and deliver updates on an incident to all data subjects involved into it. Furthermore, our role as a representative is to facilitate the communication between data subjects in Europe and the UK and Frappe, meaning that in case you have any questions, please feel free to reach out to us and we shall assist you in case it's privacy related. Our role as a representative doesn't stop with the data subject. We also facilitate the communication with partners and B2B clients. There, of course, our role is a little bit different. We assist with all the standard information for a partner, such as the information needed for standard contractual clauses or a DPA. We provide in the DSR tool the functionality and the system to hand over a data subject request from the processor to the controller. And of course, also the data breach notification goes from the processor directly to the controller, including also the generated notification to the authority. Furthermore, similar to data subject, we are there to facilitate the communication and intermediate between the processor and the controller to educate about privacy regulations, to provide updates on it, and to assist in case any questions arise in that relationship. Other than that, we are a law firm, and as a law firm, it is our core service to assist Frappe also with legal support if needed around the documentation, around international data transfer, which is a very fast evolving area in privacy, and other legal advice if needed. So with that, let me jump into a short demo how to use the DSR tool to exercise your privacy rights. Ankita already told about the privacy policy Frappe has done. I opened the example for Frappe School. in this privacy policy, you can see at the bottom here the information for users in the EU and the UK with a link to the so-called compliance landing page. And if you go on this compliance landing page, you will find on the one hand the verifications on the representation here, and on the other hand you find the access point for the data subject request. So we suggest an applicable legal framework when running through that, based on the IP address. Currently I'm in Austria, and therefore I'm suggested with the European legal framework for GDPR. So I go ahead with the European legal framework, and then I can exercise all my rights as a data subject related to this role. The most common ones are the right to access data or the right to delete data. To delete data is the, let's say, the predominant one. So let's take this one. And you can fill out a short form as a data subject, in which capacity you do the request. Are you an existing user, a website visitor, an employee, whatever. You give some data on the identification. This depends now on the company. Some ask you for an email address, others ask you for a phone number. This depends on what Frappe is using to identify you in their system as a user. In case you have any further questions or related information, you can include this here, and then you submit the request as a data subject. You get an immediate acknowledgement of this request with a unique identifier to it, and this landing page, which is accessible to you in case you verify your email address. On this landing page, you will get all the updates on the request. So if Frappe needs a further proof of the identification, if there is a question on any other related issue to this request, you will get all the information here on this website. And as a data subject, you get an information via email that you can visit this site because there is an update to it. You will also get, once Frappe handled the request internally, an update that this request is now closed, and you can then download the final information on that. So we prepared another request where this already was done. So in this case, this request is now already closed. You can see here that Frappe retained some data due to a legal obligation to do so, for namely for tax purposes, and retained our invoices, contact details, and the information related to these invoices. As a data subject, you can then download a PDF, which shows like this. We, as the representative of Frappe, inform you that this request was closed. You get all the obligatory information behind it, and you have here an audit trail on what has happened and the information on the request itself. Ankita, with that, I hand it over again to you.
So if you have any queries in relation to this webinar, if you have any queries in relation to GDPR, you can actually reach to us on legal@erpnext.com. If you shoot us an email, we will be reverting you and helping you in relation to your query. Also, if you're in the EU region or you want to generate a data subject request, you can actually do it via Prighter as well. As Andreas and Katharina has beautifully demonstrated, you can also go through our landing page. We can share the link with you, and you can actually go through there and generate the data subject request directly to us.
Sure. So thank you everyone for being present today, for taking your time out. And thanks a lot to Prighter, who came and presented their, how they have been working with us. Amazing presentation there.